So now we're going to see if the High Court regards it or disregards it. Now we'll see if it's in the judgment. Read that judgment, because the West Australian matter changed the whole electoral structure. Flicker over, mate. Now look at the Electoral Distribution Act 1947, section 13. Amendments to be passed by absolute majorities. Hello. Look at what they're saying. It shall not be lawful to present to the Governor for Her Majesty's send any bill to amend this Act unless the second and third readings of such bills shall have been passed with the concurrence of an absolute majority of the Legislative Council, Legislative Assembly. Next one. Here's the Marquette matter. Attorney General West Australia versus Marquette Decision Clause 9. On 19th December 2001, the Legislative Council of West Australia completed its consideration of the repeal bill. In the Legislative Assembly, an absolute majority of members had voted in favour of the bill. In the Legislative Council, a majority of the members of that House then present and voted for the bill, but it was not passed by an absolute majority. Hello. That's the court saying that. You're being slam dunked by Freemasonry. The spirit of Freemasonry is the spirit of the mother. That's why she's in here tonight. And that's the one that's keeping your churches wrapped up tighter than a drum. Next one, mate. Or was that it? Now, in West Australia, that's probably the biggest piece of constitutional rape that I've ever encountered, and I'm only a farmer. But I do know that the elector owns the Constitution, which means don't touch it without their consent. So part 2 of this Acts Amendment Repeal Courts and Legal Practice Act, you have the repeal of the Legal Practitioners Act. Oh, hello. That's the repeal of the Oath of Allegiance, same as Victoria did in the year 2000. Part 5 is amendments relating to state solicitor and savings provision. Well, that's who showed up in the court on Thursday from the State Solicitor's Office. Problem is, they've taken the Crown out of Part 5. So in legal terms, could they have been at the bar table?
No.
You're the jury, not them. Because this is an elector's decision from a jury. Part 8, amendments about the Crown. Now, the moment you touch that, you've touched Section 128 of the Commonwealth Constitution. Or am I wrong? Because it's the only way you can alter the Constitution. And the state constitutions are all subject to the Commonwealth Constitution. You saw all that. You're the jury. Now, this is what Peter Foss said, QC, former Attorney General, Hansard, page 13154. These are big words from a QC, because they're actually a written legal opinion. It comes through Hansard's. I have some amendments on the notice paper, which are not really amendments, they are to delete parts 5 and 8. However, I have a point to raise now. I believe that part 5 and 8 are ultra vires the Act. He's saying you're without authority before you begin. It's a QC. Now, the rest of the Parliament are all what you call donkeys from various trades and occupations and whatever, not too many legally qualified. So in essence, they don't know what they're talking about. Now, if they did get written legal opinion, that should be a public document, shouldn't it? Yes. Ask them for it. Ask them for who wrote your written legal opinion before you did this donkey drop. And anything that's not a written legal opinion is to be disregarded as hearsay. Now, Peter Foss has put his name on that to say, here's my written legal opinion. He spoke it in the West Australian Parliament, it's recorded in Hansard, which is how that written legal opinion occurs. He's saying it's ultra vires, beyond authority. What's the jury saying? Are you agreeing with Peter Foss or disagreeing?
No, agree.
That's all you need to be a jury. Hansard, page 13158. Members will see when we get to part 8 that removing the word Crown and substituting state is a very different concept altogether. That is because there is no such entity as the state. Now, you have a big problem there. Part 8, amendments about the Crown. Now, these are the acts that's in Part 8. You've got 2, 4, 6, 8, 10. I won't read them all. Go back, please, Darren. Look at the bottom one. The Supreme Court Act is amended. But there was a writ last Thursday in the Supreme Court before a judge who knows full well that the Supreme Court Act has taken the Crown out. And that's why there was a challenge to, not to the jurisdiction of the court, because that's Her Majesty's court, but to the conduct of the officers in the court. It's a different challenge. And that's why during the course of it, he said, I'll have to look at all the facts to see if I have jurisdiction or not. Could we tell him what he's got?
Yes.
Because look at the next bits. Section 125, District Court amended. Section 11 is amended by deleting Her Majesty and setting instead the Governor. That's why we took a writ. Is he allowed to do that?
No.
You're the jury. They're saying strike out this action and there's no cause of action. Is that cause of action?
Yes.
Because that's breach of contract.
Yes.
But is it treason?
Yes.
Well, you've got to present all the facts before you get an yes. And they've got the right to present the counterfacts. But all I'm saying is ring the bell for the jury trial. This table's saying this, that table's saying the diametrically opposite, but ring the bell. Oh, I'm not going to get that because we've got a whole lot of economic flutters happening and Rudd's got to get on planes and go and sort it out and give government guarantees to bank deposits. Not what the paper's written on. Section 130 Supreme Court Act. Look at that. Section 9, chuck out Her Majesty and put the Governor there. Well, who formed the Parliament? That was after he turfed her. See the title? Unlawful Government. Am I getting anywhere?
Yes.
All I'm saying is the other side would be diametrically opposed, but at the moment they've got to counter all this. They've got a big problem. And look, they changed the Royal Arms. I think they fixed that one. But were they in legal authority to fix anything?
No.
That's the problem. Section 119 is amended by deleting to Her Majesty or any of her subjects. Well, hello, that's us. So they even wrote us out. But I thought we owned it.
We do.
So what are we saying? The tenant now owns the block of flats? Because the owner went to Greece for a couple of years. But the owner was well greased there, if you got my drift. And went straight down the toilet. Why? Because they're all sound asleep in the spirit. But who did that? The spiritual mother. That's why she's in the back of this. Or other persons entitled like manner as subjects. So they took anyone who might even think they were a subject and wiped them out. Section 154 is amended by deleting Her Majesty. Now that used to say Her Majesty's Attorney General. A bit of a swift bit of the pen now says the Attorney General. Well, here you're writing stuff into contracts that are not agreed or consented to. Is this serious stuff or what?
Yes.
Is this taking the kids from a jurisprudence we knew and trusted to a jurisprudence they don't even know or we don't even know?
Yes.
Should we let them go there?
No.
Well, Aussie, wake up your preachers and wake them up graciously. It's real easy to wake them up. You just simply say, I'll reveal treason to you, you've got 7 days, or you're going to go down to a grand jury's list that you were informed of this today. And get up and preach it. Because what is that? That's truth. And they even put it up on their walls. We will show you the truth. Come to our church. Because Jesus is the way, the truth and the life. Come to us and we'll give you the truth. Are they?
No.
Because truth cannot live with a lie. That's not truth. 75% of truth is still a lie. Because it's the bit you wanted, the bit you left out, that you know it's a lie, so you've got to leave it out. So we had what you call Curly the other day saying there was no need